go.
Okay. Maybe make sure that my phone is silent too, just to not be interrupted.
Worst case scenario, if we can't hear you, we'll do a quick adjustment.
Oh, yeah, and then they wanted me to tuck this in for aesthetic purposes, as he said. All right.
Looking sharp.
All right, thank you.
You're welcome. Well, good afternoon. It's a pleasure to see everybody and to welcome them to this very unique opportunity with Professor Carson Holloway. My name is Don Steluto. I'm the co-director for the Center for Citizenship and Constitutional Government. One of the great delights that we have is engaging guest speakers in our university community on a range of big questions around big ideas. Certainly, that's what we have today. And I'd like to introduce two folks who are going to help us with the program today. First of all, we have Professor Christina Bambrick, who has done a marvelous job in raising this topic, first through her class and then bringing Professor Holloway here for this lecture. So it's due to her efforts, and for all of her efforts, we're going to put her to work during the question and answer session. She'll be moderating all the questions and answers. And then we have a great tradition of having our students introduce our guest speakers. Sorry about that, Abraham. Today, Abraham Figueroa, one of our Tocqueville Fellows, is introducing our guest. Abraham is a senior from Carthage, Missouri. I asked before if you were a Carthaginian. We'll get into that later. He is pursuing a BA in political science and a minor in constitutional studies, bless you, and he is a Tocqueville Fellow. With that, I will turn it over to Abraham to introduce our guest speaker. Abraham, welcome.
Good afternoon, and thank you for joining us. We are delighted to have Dr. Carson Holloway join us. Dr. Holloway is the Ralph Wardle Diamond Professor of Arts and Sciences and Professor of Political Science at the University of Nebraska. He is also a Washington Fellow in the Claremont Institute's Center for the American Way of Life. Professor Holloway is the author of Hamilton versus Jefferson in the Washington administration, Completing the Founding or Betraying the Founding, Cambridge University Press, 2015. His scholarly articles have appeared in the Review of Politics, Interpretation, a Journal of Political Philosophy, and Perspectives on Political Science. He has written more popular articles for First Things, The New Criterion, National Affairs, Public Discourse, National Review, Law and Liberty, The Federalist, The American Spectator, and The American Conservative. Professor Holloway received his BA from the University of Northern Iowa and his Ph.D. from Northern Illinois University. Thank you for joining us, Professor.
All right, thank you. All right. Thanks for that kind introduction. I just noticed from that picture I'm wearing the same tie, so you'll all recognize me. Yeah, it's a real pleasure to be back. I had one of those cases of chronological whiplash you get when you get older, because I was thinking about coming. I thought, I was at Notre Dame a few years ago, and then it occurred to me that was 2002. We were on that panel together, so that's longer ago than I thought it was. I think Professor Munoz, we should make it a regular thing and book me for 2046. We can talk about that afterwards. It's an honor to be at Notre Dame. I suppose some of you know the movie Rudy, where his father walks into Notre Dame Stadium and says, "This is the greatest day of my life." That's how I feel when I walk into Christina's classroom. So it's a pleasure and an honor to be here. And I'm going to speak about, as you know, New York Times versus Sullivan and the original meaning of the First Amendment. So let me start with a couple of preliminary points and then give you an overview of the talk, and then I will deliver the talk and we'll have time for questions afterwards. The preliminary question might be, why are we talking about this? And I think the answer to that question, or one answer, is it has become controversial in recent years in a way that it wasn't for a long time. I think when New York Times versus Sullivan was originally decided in 1964, it was an innovation in American constitutional law, but I don't think it provoked the kind of backlash that other cases did from that era. Certainly not, for example, in the area of school prayer, where there was a lot of unhappiness about an opinion like that. If people had bumper stickers, as they did on their cars back in the 1960s, that said, "Impeach Earl Warren," I don't think this is one of the reasons. There were other reasons that people thought that. And then after that, I would add, I think the case became rather revered as a landmark ruling in modern free speech standards. And certainly I know from talking to some of them that journalists are really taught to venerate the New York Times versus Sullivan opinion and the actual malice standard that arises from it. But it has become more controversial in recent years, called into question by prominent political figures and even some prominent jurists. I think of the political figures, former President Trump, who's running for office again. Back in 2016, he's not admittedly an expert in American constitutional law, but when he said things like, we need to tighten up our libel laws, he was thinking about something related to the New York Times versus Sullivan standard. Somebody like Governor DeSantis of Florida, who probably does know more about these things, being a lawyer, has also called it into question. And he really hasn't sponsored any legislation, but some people in the Florida legislature have, which has not been enacted yet. But it was designed, it seemed, to challenge the actual malice standard. And then also prominent jurists as well. I'm thinking of Justice Clarence Thomas, who's written some concurring opinions suggesting that the actual malice standard is more or less made up by the court and needs to be revisited. And then also Justice Gorsuch has joined in, although making more of a kind of pragmatic or policy argument that the nature of our discourse has changed with social media and things like that. And so maybe we need to rethink the conditions that led to the actual malice standard in the first place. So I think that's why we're talking about this as a preliminary point. And then in general, I think you could say, you can tell from the title of my talk that you could view it as an originalist critique of the actual malice standard. If you don't agree with let me put it this way. If you do agree with originalism, you might think that when I'm done, that the Sullivan court has a lot of explaining to do for what it did. If you don't agree with originalism, it would still be interesting to see how much the modern standards of freedom of the press differ from the ones that the founders envisioned. And I guess if you're an opponent of originalism, you might argue that, see, this shows that the court doesn't always do originalism, so maybe it's not the appropriate approach in every case. And certainly there would be serious consequences if the court were to return entirely to the original understanding of freedom of the press and of speech, I believe. So what is to come can be divided into 4 parts. What I'd like to do in the time I have is talk about New York Times versus Sullivan and the actual malice doctrine and its subsequent development in approximately the decade after 1964. Just kind of set the stage with that. And then secondly, I would like to talk about the original understanding of the First Amendment, how the founders understood the First Amendment, freedom of the press, and the question of libel. In the third place, I would like to speak about Justice Brennan's, what I will call, please accept this from me provisionally, Justice Brennan's spurious originalism, in his opinion. He does make a kind of originalist argument, and I want to treat him seriously by telling you what it is and then saying what I think is mistaken about it. So that'll be the third part. And then finally, in the fourth section, I would like to speak about the right to reputation and the original meaning of the First Amendment. Okay, so part 1, New York Times versus Sullivan and the development of the actual malice standard. Let me say a little bit about the origins of the case. It's not a civil rights case, it's a civil liberties case, if you accept the distinctions that people make when they study constitutional law. But it arose from the civil rights movement. Of course, the most famous leader of the civil rights movement is Martin Luther King. Martin Luther King was subjected to what I think most people agree is an abusive prosecution for tax fraud, for allegedly mishandling some money for one of the organizations for which he worked. Basically, from what I've read, all he did was deposit it in his account and then transfer it to the account of the organization. And some Southern authorities thought, aha, this is our chance to push back on him. And I think the case, pretty much everybody would agree, was a politically motivated case to kind of damage his reputation. It does speak well for the jurors that they found him innocent in that case. But before that could happen, some folks got together and put together the Committee to Defend Martin Luther King and the Struggle for Freedom in the South. So a group of people to defend Dr. King's efforts, raise money for him and for his defense, but also to further advance the agenda of the civil rights movement. And that group put a paid political ad in the New York Times, Heed Their Rising Voices, which was intended as a defense of Dr. King and a complaint about some of the harassment that he had suffered and threats, worse than harassment, and also a critique of, I think, Southern official intransigence and intimidation in the face of efforts to desegregate. A couple things that are important about Heed Their Rising Voices that relate to the libel case that arise from it are that it was admittedly erroneous in some respects. Not all the facts were entirely accurate. And, also of interest, the Supreme Court, of course, one of the greatest newspapers in the history of the United States, the leading newspaper at that time, very good fact-checking operation, which they really didn't apply to that ad. It was sort of rushed into print. So, there were some errors. It's not flattering to people in the South in general, which is also important to the story. And L.B. Sullivan, who was city commissioner for the city of Montgomery, felt that it defamed him. There were criticisms of the police in the ad, their conduct. Some of the things were erroneous. Sullivan felt that as a city commissioner to whom the police reported, and that was his bailiwick, right, that the ad defamed him, so he sued in the courts of Alabama, and he won, and they, in Times, appealed to the Supreme Court of Alabama, and they affirmed the ruling and awarded him $500,000, which is a lot of money, especially in 1964 dollars, and very concerning, I think, to the courts, as we'll see. Not surprisingly, the New York Times appealed to the Supreme Court of the United States, and from the standpoint of the traditional standards, the Times surprisingly won and introduced this actual malice doctrine that I'm going to tell you about in just a moment. But before I do, since I'm being critical of the actual malice doctrine, I did want to draw a distinction between the ruling in the case and the doctrine in the case. I think it's fair to say that Sullivan did not deserve to win, right? And the Supreme Court had good reasons to do what it did in New York Times versus Sullivan. Pretty powerful political reasons, which I'll float out with some hesitation because I don't think courts should behave politically, but it was not the only case. There were other cases. The governor was suing as well. And people had said in the Alabama newspapers that they viewed cases like this as a way to checkmate the New York Times and stop it from making the South look bad. I think I was talking to Professor Maverick before class about Samantha Barbas's book on New York Times versus Sullivan. She's a historian with a new book on the case and its relationship to the civil rights movement. Very good, very detailed account of the circumstances out of which the case arose. And as she points out, a lot of Southerners felt a kind of resentment about coverage of their problems by northern liberal newspapers in big cities that also had race problems that they don't talk about, right? So they feel like they're getting defamed unfairly because of a problem that's really an American problem and not exclusively a Southern problem. So there's a lot of appetite in the South to sue these newspapers and make them stop criticizing us. And certainly these kinds of awards could stop the Times from covering the civil rights movement, and the Times' coverage of the civil rights movement was the leading coverage at the time. So I don't think the court wanted to see that happen. That would be a grave outcome if the leading newspaper could not cover one of the most important topics of the time. Legally, an argument that I would float out with maybe a little more confidence is, you know, the ad did not even mention Sullivan's name, right? The case that he was defamed by this ad is weak in a couple of respects. One, as some people have pointed out, if you get painted as an intransigent opponent of segregation in the newspapers in Alabama in 1960, that's not exactly going to hurt your reputation, right? But more importantly, perhaps, he was not mentioned. He's kind of having to argue that he was defamed by implication because of the relationship between him and the police, and also the fact that, as Justice Brennan points out in his opinion in the case, the witnesses he called in the trial even said themselves, I didn't think that stuff was true. You know, I think it would be hurtful to his reputation if it were true, but they didn't even believe it. So the idea that, I mean, I don't want to get into the distinction, although we could talk about it later, between like general damages and actual damages, but the idea that Sullivan had suffered $500,000 worth of damage to his life is kind of hard to believe. So you can see why the court would say, you don't deserve to win. But they did something else that's very important and very consequential for the long term, which is they introduced this actual malice doctrine as a new way of looking at a certain subset of libel cases that arise under the, libel cases that will have to be examined under the First Amendment. So let me tell you what the actual malice doctrine is, and I'll say something about why they thought they had to invent it and apply it. So in an ordinary libel suit, I think you would have to demonstrate, according to the traditional standards, that you had been the victim of defamatory falsehood, and maybe also that the publisher had behaved with some negligence or carelessness. Maybe not. But with the actual malice standard, you have to demonstrate more. You would have to demonstrate that, and the court said, if you are a public official, and if the libel has to do with your official conduct, you will have to demonstrate actual malice. Actual malice doesn't actually mean what it sounds like it means. It's a legal term of art. The court said you will have to demonstrate either that the publisher knew that the things they were saying were false, or at least they acted with reckless disregard for the truth. So it's a two-tiered system now, with one set of standards for ordinary people, another set of standards for public officials, and harder standards for public officials, right? It's very hard for a public official to prevail under these standards, which is one of the reasons we don't have so many libel suits brought by public officials anymore. Why did the court do this? Let me use an expression that some of you will be familiar with, that's not used by the court, but used later, but I think it explains what was on their minds, so-called chilling effect, right? They're worried that, although they don't want to say that there shouldn't be any libel cases, but they think libel cases might potentially have a chilling effect on the robust public discourse that you need for democratic self-government. And as they point out, Justice William Brennan's opinion is for the court. He's certainly correct about this. There can be abusive libel cases brought by rich people or well-connected people who just want to make life tough on somebody who said something critical. So they're worried about that chilling effect on this form of discourse that is of very high value under the First Amendment. Talk about politicians and criticizing politicians. So that's understandable. Nevertheless, it is the case that the actual malice standard is a novelty in American constitutional law in the federal sense. Some states had moved in this direction, but not a majority of them. And what some states do is, of course, not it doesn't have compelling authority for how you understand the First Amendment of the federal Constitution. So the court had some things in state common law development that it could grab onto, getting the actual malice doctrine, but then it imposed it on the First Amendment of the United States for these reasons. Let me say a few words about subsequent developments determining the scope of the doctrine, and then I'll move on to part two. So, Sullivan opinion leaves some questions open about the potential scope of the doctrine. And with scope, I have two things in mind. One, the kind of law to which it applies. In the second place, the kind of litigant to whom it applies. Kinds of law, it's important to remember, in the American tradition, the Anglo-American tradition, going back into the common law, there is both civil libel and criminal libel. You can sue for damages if somebody damages your reputation unjustly. Some jurisdictions, there could be a criminal prosecution for certain forms of libel. So the question arises, does the Sullivan doctrine apply to criminal libel as well as civil libel? New York Times versus Sullivan was a civil suit. They handled that pretty quickly later the same year in Garrison versus New Orleans. I'm sorry, I think it's Garrison versus Louisiana. I have a typo in my notes. 1964. The Garrison, by the way, if you want to know, is a famous person for other reasons. If anybody's ever seen Oliver Stone's film JFK, right? Jim Garrison is the guy who took it upon himself to investigate the assassination of the president. He also took it upon himself in a press conference to say that he thought the judges of his district were corrupt and in the pay of racketeers and lazy. And so he got prosecuted for criminal libel for having said that. And it went up to the Supreme Court, and the court said, well, we have to apply the actual malice doctrine, which makes sense if you accept the premise, right? Like if you're worried that a civil suit would have a chilling effect on public discourse, certainly a criminal case would as well, if you can go to prison or be fined. So that's a pretty logical step to take. I think something else that was also clarified helpfully in the Garrison case and some other ones is, what do we mean by recklessness? Brennan's very clear in that case because one of the lower court judges had talked about whether a reasonable person would have believed this kind of thing, whether a prudent person could have said such a thing, and Brennan's careful to say, actual malice standard is not predicated on negligence or reasonableness, it's reckless disregard, right? So it has to be something worse than ordinary negligence. So the actual malice doctrine applies to criminal as well as to civil libel. The more complicated thing that the court had to grapple with for a few years is, what litigants does this apply to? What kind of plaintiffs does this doctrine apply to? New York Times versus Sullivan, it's public officials, right? Which is already a fairly expansive category because you can take it all the way down to local mayor, school board member, something like that. These are not all very powerful people, as is the case in a way with Sullivan. He's just a city councilor. It's not just the president, in other words, or members of Congress. But as some of you may know, The mature form of the actual malice doctrine says that it applies to public figures, right, which is different from public officials. What's a public figure? Turns out a public figure is somebody who is prominent in a way. They're either at the forefront of the country's consciousness in general, or if you're a so-called special or limited purpose public figure, you're at the forefront of some specific controversy. I spent some time getting to that. There's a couple of interesting cases in the late 60s. Curtis Publishing Company versus Butts and AP versus Walker. Walker was a retired general who was an activist against integration, who got involved in, he was in some protest in the South, and it got violent, and the newspaper accounts suggested that he had encouraged people to engage in lawless action, and he hadn't really done that, so he sued Butts. The Butts case is kind of funny in a way. If you're going to go into journalism and you want a primer on how not to act, the Saturday Evening Post published an article saying that Butts, who was the athletic director for the University of Georgia, not incidentally a public employee because that position was paid for by a private foundation, that he had conspired with somebody the older folks in the audience will have heard of, Bear Bryant, the coach of Alabama. Some of the younger people might not have heard of him, but he was a legendary coach. And somebody overheard this guy's conversation with Bear Bryant. He told the Saturday Evening Post he's fixing games. So they published that article. And they made a couple of mistakes. One is they didn't think of the possibility, which turned out to be true, that Butts and Bear Bryant were just talking about football in general, and he wasn't telling them anything that was of special knowledge that would lead you to fix a game, right? Like I don't know that much about football, I hate to admit that here, but if you tell an opposing person that we're working on the forward pass or something, you're not telling them anything about how a particular game is going to be conducted. You're not fixing a game. So they didn't do a very good job there. And then the other thing I like to say as an aside that makes it a little bit amusing is the Saturday Evening Post, which was making this story part of their move into investigative journalism, not only defamed Butts, but they put either in the introduction or near the conclusion a sentence that said, "This story will certainly destroy Butts' reputation," which is like you're inviting a lawsuit if you say something like that. So these cases are kind of messy because you have these situations where there's a majority for the outcome, but not a clear majority for the reasoning, as we see sometimes. And so it's not entirely clear where this is going to end up for that reason, and also because our friend Justice Brennan, who wrote the original opinion, also starts around this time to float out the idea that maybe the actual malice doctrine should apply in cases of public interest. So this is a lot broader, right, and would rope in people who aren't even public figures. And there's another case I like to mention, Rosenblum versus Metro Media, where he made that argument and the court did not accept it, but that was also one of these messy cases where it's not clear. Things are developing, right? Rosenblum sold, how do I want to put it? Dirty magazines, right? And he was arrested for that, and it was in the newspaper that he was peddling obscenity. But just as the libel standards were becoming more liberal in the late 1960s, so were the obscenity standards. So he was not successfully prosecuted. These were admittedly, quote unquote, nudist magazines, but they weren't obscene, so he sued. Now, Rosenblum is just a magazine seller. He's not even a public figure. So that raises an interesting question. And Brennan uses the case as this occasion to say, well, I really think the actual malice standard should apply when there's anything of public interest that's being discussed. Certainly an arrest of somebody by the police is of public interest. So the question is, will we go that far? What happens in the last case I'll mention here, Gertz versus Welch, which was written by Lewis Powell, the leading centrist on the court at the time for a long time. In Gertz versus Welch, 1974, the court solidified the public figure interpretation. We will take the actual malice standard that far, but we will not go into public issues. Brennan kind of gets brushed back. So it does advance considerably, but it doesn't go as far as Brennan wanted it to go. And one last thing on this section, what are the arguments here? They're familiar, but they're developed a little bit more. The court's still concerned about the chilling effect. We have to be mindful of the need to protect people in their ability to discuss even controversial questions that will involve criticism of public figures, public officials, and bearing in mind that it's very hard, as Brennan says and as Powell says, to guarantee that everything you say about politics is strictly factually accurate, right? So there's that. Also, though, he introduces a couple of distinctions that are interesting and worth mentioning. and one of them has a long history, which I can talk about later under questioning if you want me to. He says, look, there's an empirical and a normative difference between public figures and ordinary people. The empirical difference is public figures have more access to the press. To take an example, who's the most famous public figure in our time who's not a public official? Probably former President Trump. If somebody says something about him that's not true and hurtful to his reputation, he has a lot of ability to set the record straight on his own, right? He's got his Truth Social account. He can go to the press and they'll reprint what he says. So as Powell says, the first step in any case of defamation is self-help. You go correct the record. Public figures can do that more easily than ordinary people. The normative difference, he says, is that, and this is the part that I think has a long history to it, public figures have tacitly consented to a greater risk of defamation than ordinary people have. If you're going to get involved in politics, some nasty things are going to be said about you, and you should know that. Whereas an ordinary person who just on the street gets defamed, that's a different thing. So Powell says, for that reason, we think there's strong normative reasons to give more stringent protection to the reputation of ordinary people. Okay, part one. Part two, libel and the original meaning of the freedom of the press. My argument is that the actual malice doctrine is not rooted in the original public meaning of the First Amendment. And I'll work my way into that by starting with the text. The text is very ambiguous, in a way, in relation to these issues. Congress shall make no law abridging the freedom of the press, right? So as Chief Justice John Marshall said in Gibbons versus Ogden, quoting an able member of the bar who had argued before the court in that case, was ably said by a gentleman at the bar. Marshall says, our Constitution is one of enumeration, not of definition, right? So commerce is mentioned, but do we know what commerce is? We need to figure that out. I think you could say the same thing about freedom of the press. And the text itself seems to point to some pre-existing understanding of what it is, the freedom of the press, just like habeas corpus or other things that are protected in the Constitution or the Bill of Rights. And I think this is supported by looking at the political history of the ratification of the First Amendment. Who wanted freedom of the press protected in the Constitution? The Anti-Federalists. It's not in the original Constitution. That becomes a point of criticism with the Anti-Federalists who are opposed to ratification. And if you read them, you will see that they don't come forward and say, hey, we have this great new idea called freedom of the press, right? They say, what's wrong with you guys that you didn't protect the freedom of the press? This is a well-known concept, cherished by Americans. Why is it not in the Constitution? So it does seem to suggest that there's a pre-existing public understanding. How would we find out what that is? One good place to start, according to my argument, is with William Blackstone and his commentaries on the laws of England. Blackstone, like all of the people I'll talk about, treats, like the modern court, freedom of the press as very important to what we would call democratic government or republican self-government, or the exercise of the rights of suffrage, as some of the early commentators say. You have to have freedom of speech if your vote is going to mean anything, so that people can vote in an informed way. At the same time, Blackstone, who was very influential on the founders, as some of the leading lawyers of the age say, he's read by everybody, kind of the textbook in English law at the time of the founding. Blackstone makes a distinction that's very familiar to the founders, and one that I think the center probably would agree is an important distinction between liberty and license. Liberty and licentiousness. Liberty is the freedom to do everything that is decent and just and lawful. Licentiousness is the freedom to do just whatever you want to. And Blackstone says we have to keep clear the distinction between the liberty of the press and the licentiousness of the press. And he's very clear that libel belongs with the licentiousness of the press, that is to say, outside the scope of the freedom of the press. So here's Blackstone, just for a moment. Liberty of the press, properly understood, is by no means infringed or violated where libels are punished under English law. Also, I have to admit this because it's something that is a little bit sobering, but you should know about. Blackstone suggests that liberty of the press means that there is no prior restraint upon the press. There will have no censorship, no licensing, but you can be held to account what you published after the fact, if it was unlawful in some way. Now, there are three people I'd like to mention that I guess we could call American Blackstones, who show that many prominent Americans adhered to this view in its essentials. There's some ways in which the Americans liberalized the common law that Blackstone was talking about. And again, I could talk about that more under questioning, perhaps. But I think they retained the essentials in relation to what we're talking about here. The idea that there's a distinction between liberty and license of the press, and that libel is outside the scope, and therefore not in need of and not properly understood as being protected. So James Wilson, in his lectures on law, James Wilson's one of the framers of the Constitution, one of the leading lawyers among the founders, wrote in his lectures on law, "Citizens under a free government have a right to think, to speak, to write, to print, and to publish freely, but with decency and truth concerning public men, public bodies, and public measures." So there's a nice marker for the distinction between what is licentious and what is truly free. James Kent, Chancellor Kent, famous New York lawyer, Federalist, friend of Alexander Hamilton, published his massive commentaries on American law, which were used throughout most of the 19th century. I think that one of the last revisions of that work was by Oliver Wendell Holmes, so it had a lot of staying power. Basically tells you the same thing. He praises freedom of the press, but then he adds, libel is a legal grievance, and the law has accordingly considered it in the light of a public as well as a private injury. So we have criminal libel laws and civil libel laws. And then finally, I like to mention Joseph Story, the author of the Commentaries on the Constitution of the United States, an Associate Justice, a close friend to Chief Justice Marshall. If you want to read it, and it's really great, he says a lot that is pretty recognizably Blackstonian in his commentary on the First Amendment. I also like to cite what he says in Dexter versus Speer, which is a libel case he handled in 1825 on circuit. So it's not a Supreme Court case, but as you know, at the time, Supreme Court justices also just heard trial court cases. And so in Dexter versus Speer, he said this, just to clarify for the jury what they had to think about. No man has a right to state of another that which is false and injurious to him. Consequently, no man has a right to give it wider range and more mischievous range by publishing it in a newspaper. And then very strikingly he says, because he's talking about libel and the freedom of the press, he says, and I quote, "The liberty of the press has nothing to do with this subject." Right? It's completely separate. If you've libeled somebody, then you've thrown the liberty of the press out the door and it's not coming into court as far as he's concerned. So that's a few examples of the founding era understanding of this question. And to sum up what I think is the bearing of it upon the Sullivan doctrine, you'll notice two things. One is that the basis of the Sullivan inquiry is absent in the founders' thinking. In other words, the Sullivan court starts from the idea that if someone is on the receiving end of a libel suit by a public official, then our First Amendment alarm bells should go off. There is a problem. There's a constitutional issue at stake here. Whereas the founding understanding is there is no issue at stake because freedom of the press is totally different from this kind of behavior. That's why I wanted to say it's outside the scope. You just don't have the constitutional question raised that is then the vehicle for the court to get where it gets in the actual malice doctrine. And then that's the second point, which is the specifics of the actual malice doctrine are just not in the thinking of founders. They don't ever say, they do actually say in some instances, and again, if you want to push me on this, I can talk about it later. They do recognize certain areas where public officials might be treated differently under libel standards than ordinary people would, or public men, to use their language, but not in this way. And they never suggest that you would have to demonstrate actual malice to prevail if the thing that had been published about you had been actually admittedly defamatory and false. Okay, part 3. Let me talk about Justice Brennan's kind of originalist argument. And here's how he builds into it. Justice Brennan, of course, I didn't say this, but everybody here knows this, most consequential liberal justice on the court in his time, right? I mean, one of the most important people on the court in the second half of the 20th century. And very smart and very influential in a lot of areas. Here's how he builds into this argument about the founding. He cites some precedents showing that the First Amendment protects you in saying things that are critical of public people, things that hurt their reputation. Then he cites some other precedents showing that the First Amendment protects erroneous statements. And then from there, he goes to the idea that, well, if erroneous statements are protected and defamatory statements are protected, then presumably if we put them together, they're still protected. False defamatory statements are within the scope of the First Amendment's protection. And to sustain that view, he does turn to the founding. and the controversy over the Sedition Act. He says the Sedition Act controversy of 1798 and the next couple of years shows that this idea is correct, that the First Amendment does protect things that are false and defamatory. And he approaches it in this way. He says, here's what I'd say. He makes a kind of argument based upon what I would call, and I'm not the first one to say this, of course, but like practical construction. He does this because he says, the question never came before this court, the Supreme Court of the United States. But it was agreed that the Sedition Act, rather, was held unconstitutional in the court of history, right? And so by the court of history, he means by subsequent political developments. And he shows that a later Congress in the 1830s repaid the fines levied under the Sedition Act on the understanding it was unconstitutional. Jefferson, as president, pardoned people under the Sedition Act because, as he said, I considered it to be as palpable a violation of the Constitution as if Congress had ordered us all to kneel down and worship a golden image. Right? It's kind of, to me, typical Jeffersonian dogmatic overstatement, which I'll try to explain why I feel that way in a moment. So that's Brennan's argument. And he also relies a lot on James Madison, too, because Madison's another leading critic of the Sedition Act. Well, I guess let me say one more thing here before I go on about why this is important to his understanding. Right? The Sedition Act punished defamation of the government of the United States, the Congress, members of the Congress, the president. Right? The Federalist authors of the Sedition Act in the Federalist Congress of 1798 were careful in the way they wrote it to make it applicable to false, malicious, defamatory statements. Okay? So the statement has to be false in order to be actionable. And there's a separate paragraph that makes it clear that anybody charged under the Act can mount a defense based upon the truth of what they said. Right? This opens up the whole misunderstanding, or the disagreement rather, between the Federalists and the Jeffersonian Republican critics of the Act. Under the common law standards that Blackstone teaches, and that apparently were prevailing at the time, a criminal libel did not have to be false. Right? You could get in trouble for criminal libel even if the thing you said was true. And the reason they thought that way was because, as Blackstone says, criminal libels were considered as threats to breach of peace. Just think about it. Even if it's true, if I could dredge up the worst thing about me, the most embarrassing thing, even if it's true and you publish it in the newspaper, I might get mad, right? Now, I'm a peaceable man and I wouldn't do anything other than pray for your soul that you'd engage in this malicious act of detraction, but other people, especially back in Blackstone's time, when everybody's armed, they might go just take it out of you, right? So they viewed criminal libel, even when true, as a threat to breach of peace. So in light of that, the Federalist authors of the Sedition Act would say, this is actually an expansion of freedom of the press, right? Because we're making clear there is a truth defense. Brennan's point is, despite that, titanic figures like Jefferson and Madison still thought it was unconstitutional, right? So he thinks that precedent stands for the idea that even the false and the defamatory is within the scope of the protection of the First Amendment. Now, here's what I think is mistaken about that. First of all, it's not clear to me that the Sedition Act was unconstitutional, even though most everybody thinks it is. That's kind of the dominant view. All I want to say, though, is that a lot of reputable people thought the Sedition Act was constitutional, and if the court is going off the founding era record, they would have to grapple with the fact that although Jefferson and Madison thought it was unconstitutional, people like Washington, Hamilton, John Adams, the ones who wrote it, thought it was constitutional, right? And there were very capable arguments made in its defense. Speaking of Supreme Court justices, James Iredell, very smart guy, North Carolinian on the Supreme Court, in his instructions to the grand jury on a Sedition Act case, is aware people have said it's unconstitutional, so he instructs the grand jury on why it's constitutional, right? He says, they say there's no enumerated power over the press, but there's a necessary and proper clause. And the government has an interest in making sure that liars don't stir up opposition to the execution of the laws. Certainly, you can punish sedition, trying to forcibly prevent the execution of the laws. Well, it's just one step removed to deal with the people who are stirring people up into sedition, especially if they're using falsehoods. And Iredell makes, I mean, a lot of people wouldn't like it, but it's not an incompetent argument about the text of the First Amendment. He says, if you read it carefully, it says, Congress shall make no law respecting an establishment of religion or abridging the freedom of the press. And he says, that sounds to me, if you assume that the drafters chose their language carefully, that they're saying Congress shall make no law about an establishment of religion, but they are allowed to make a law about the freedom of the press as long as they don't abridge it, right? So he's not, and then he invokes what I've already told you about the common law standards that would indicate this was an expansion of the freedom of the press. If I may, for one moment, even though he did not have to deal with this officially, I'd like to say something about the great Chief Justice, John Marshall. He didn't become a judge, a federal judge, until, or any kind of judge for that matter, until 1801. So he didn't have to hear any Sedition Act cases. But I think it's pretty clear from his correspondence that he would tell people, I'm not in favor of the Sedition Act. I think it's a mistake. It's stirring up trouble, making people hate the government even more. But then he goes on and says in his same letters, I don't think it's pregnant with all the evils that other people say it is. So I think it's pretty clear Marshall didn't think the Sedition Act was unconstitutional. I just mention that because he's such an important figure. So this practical construction argument and all the evidence cuts more than one way. A couple other points I'd make. I guess what I'm saying is I feel like Brennan's reliance on the Sedition Act controversy is kind of tendentious because he relies on some evidence but not other evidence. I mean, it's a little dicey to rely on Jefferson and Madison in the Sedition Act controversy because they also put out things like the compact theory of the Constitution and the argument that states have a right to interpose their authority or nullify federal law. The court doesn't want to mention that in this case. And a couple other things, and you have to be careful here, different people say different things. Characteristically, James Madison is more careful than Thomas Jefferson in practically everything, I think. I mean, Jefferson's a very smart guy. I respect him, but he says contradictory things because he tends to throw everything he's got into what he's saying at the moment, right? The Kentucky resolutions, which Jefferson authored, they even go so far as to say Congress has no power to punish any crime not defined in the Constitution. So that's like saying Congress can punish treason and counterfeiting and piracy on the high seas, but nothing else. Well, nobody thinks that's correct. I mean, Brennan would not say that's correct, right? So the understanding of the federal power is way narrower than Brennan would want to say was affirmed in the court of history. And especially, or even with regard to the specific question of the freedom of the press, right? I mean, ultimately what these Jeffersonian Republicans are arguing is that it's a different kind of argument and it's proving something different from what Brennan thinks. It's a different kind of argument because it's not an argument only about what is meant by the freedom of the press. It's an argument about what is meant by the lack of an enumerated power plus the First Amendment. And what they're saying is the federal government has no power over the press whatsoever, which I also think is something that the modern court would not agree with. I mean, if that were true, there would be no power to regulate false advertising in interstate commerce. There'd be no power in the federal government to punish publication of, say, the war plans of the government in a case where it would either defeat the war plans or get a bunch of American soldiers killed. I think even in the Pentagon Papers case, the court doesn't go so far as to say the government has no power over the press at all. So to sum this up, I think the court here is using the Sedition Act controversy as leverage to get to decide this the way they want to, whereas if they had really drilled down into the details, it would compel them to things that they wouldn't really want to affirm. And finally, even Jefferson and Madison, or let's see, at least Jefferson, I can cite the second inaugural. He says, we've had an argument about this. Fact is, the state courts are open to people who want to vindicate their reputations. So the states also had protections for the freedom of the press. I take that as evidence that even the Jeffersonian Republican critics of the Sedition Act did not think that the principle of the freedom of the press prohibits public officials from suing for libel or having to demonstrate actual malice. There's just no evidence for that. Okay, I have a few minutes left, and then we'll take questions. The last part of my talk has to do with the right of reputation and the original meaning of the First Amendment. So here we get not only into constitutional law, but a little bit into political philosophy, I think, in a helpful way. And one way of getting into this part of the argument would be to say, why does this matter? And I'd like to say something about why I think we should think that this matters, beyond just if you believe in originalism, you think that this was done incorrectly. Although the evidence I'm going to rely on here does rely on the founders, but I'll say something about why I think it's still relevant to us. If we think we shouldn't care about this or think that maybe the balance is good enough for our times, we should just leave it alone, one reason to rethink it is that the founders teach us that reputation is a right. And I think this is something that's been obscured, both by the recent developments and by older developments that are very influential. What I mean by recent developments is the court usually, not exclusively, but usually will talk about these questions as involving the right to the freedom of the press and freedom of speech versus so-and-so's reputational interests. That's kind of weighting the scales a little bit. I think the founders would say so-and-so has not an interest in his reputation or hers, but a right to their reputation. That elevates the question a little bit. The reason I say it's obscured from older sources too is, well, we're Americans. We know that John Locke's very influential on the founders. You look at the natural rights doctrine, life, liberty, and property. Locke doesn't talk about reputation much or at all, as far as I can tell. But we're reminded, if we look at these kinds of questions, that the founders don't get their understanding of rights exclusively from Locke, and they do speak about reputation as a right, and even as a natural right. Let me make the case for that by relying on Blackstone and the others I mentioned. It's very interesting. In Blackstone's commentaries on law, he says, the security of his reputation or good name from the arts of detraction and slander are rights to which every man is entitled by reason and natural justice, since without these, it's impossible to have the perfect enjoyment of any other advantage or right. So I take it Blackstone is saying that it's not just a matter of positive law that reputation is something precious and to be protected. It's a matter of natural law, something having to do with the way human beings are. And the founders I talked about before, the founding legal theorists, don't quite put it that way, but I think they are in the ballpark. For example, Chancellor Kent treats libel under a section in his commentaries on the absolute rights of persons. He says the preservation of every person's good name from the vile arts of detraction is justly included as a part of the right of personal security. James Wilson, in his commentaries on law, says, robbery itself does not flow from a fountain more rankly poisoned than that which throws out the waters of calumny and defamation. Obviously, robbery is an offense against your right to property. And if he's saying that calumny and defamation are just as bad, I think it implies that there's an equally important right to reputation. And then in the aforementioned Dexter versus Spear, Justice Story points out that the dearest property which a man has is often his good name and character. So I think they're all in agreement with this idea that human beings have a natural right to reputation. If it's a natural right, it's held by people whether they enter public life or not, something worthy of the law's protection. And I'll just say, we're almost done here. Let me give you two more things and then I'll wrap it up. I think that makes a lot of sense. If natural rights are derived from human nature, and if human beings are, it seems evident to me, sociable by nature, they care about their reputation. And I would appeal to anybody's own experience. How would you feel if somebody assaulted you? How would you feel if somebody robbed you? How would you feel if somebody defamed you in front of the whole country? The fact is, these things hurt, right? Like psychologically, even physically. If you got home and saw your house had been robbed, the subjective feelings that you would experience would probably not be worse than if you opened the newspaper tomorrow and saw some story about how you're a criminal, right? Everything's at stake. What I want to say is, I think attacks on all these rights are taken by human beings as harms to their being, right? And so it's important to bear that in mind in thinking about these questions. I'll mention this last of all just because it's been on my mind. I've been watching an old TV series called Shakespeare's Age of Kings from 1960. They did all the history plays from Richard II up to Richard III. So I've been also rereading Richard III, if you know that play. The beginning, the king is mediating a dispute between two dukes who are each accusing each other of treason, and accordingly each accusing each other of slander, right? Because each one's lying about the other. And Richard, who's not a very effectual king, that's part of the story, tries to tell him, look, you're just going to patch these things up, forget about it. They can't let it go, right? And famously, Thomas Mowbray, the Duke of Norfolk, says to the king, my dear, dear Lord, the purest treasure that mortal times afford is spotless reputation. That away men are but gilded loam or painted clay. Mine honor is my life, both grow in one. Take honor from me and my life is done. Now I will admit that that's not only human nature talking, but that's what, I see somebody has a copy of Tocqueville out or had, that's also the aristocratic social state talking, right? That's somebody who's raised with feudal ethics and how important their reputation is. But I think human nature is speaking too, because we can all recognize that if somebody accused you of treason and the authority in question said, oh, let's just forget about it, you'd be like, wait a minute, I haven't been vindicated. We can let it go when I've been vindicated. So I think that's powerful evidence from, and actually there's a lot of interesting things about reputation in Shakespeare, like Iago, right? Who steals my purse steals trash. Who steals my good name? Steals what does not enrich him, but makes me poor indeed. So that's what I wanted to end on, is some of the philosophical or anthropological considerations that support treating reputation as a right. So I'll conclude there, and thank you all for your attention, and we can take some questions here, right? Okay.
Thanks very much for such an insightful lecture, Professor Holloway. We have about 20 minutes or so, so we'll give first priority to undergraduates and then open it up. Any initial questions? All right, Professor Munoz.
It's been a long time since I've been an undergraduate. Thanks. Really, two comments. First, I think on behalf of my class, I thank you for mentioning Tocqueville. A bunch of students in here are slogging through Tocqueville with me, and they're like, you did say something that I'm glad is relevant today. So that was very good. I'm going to take issue with not something you said, but what something Iredell says, in defending the constitutionality of the Alien and Sedition Acts. Isn't the construction, these are okay, that is, Congress can limit speech or freedom of press as long as it doesn't abridge it. Isn't that the very argument that James Madison gives and Hamilton gives in Federalist 84 on why we shouldn't have a Bill of Rights? And the very construction that the Ninth Amendment is meant to prohibit? I mean, just to fill in the blank here, the argument against a Bill of Rights is if we list things that Congress can't do, it will be assumed that Congress can do everything up to that point. So if we say Congress can't abridge the freedom of the press, it will be taken to mean Congress can regulate the press as long as it doesn't abridge its freedom. That is, it will grant power. It will grant power to Congress that shouldn't be granted.
Right.
So it strikes me that that's an argument that's not supportive of the original meaning.
Yeah, and I think you have a very good point there. And I do think that the Jeffersonian Republicans had some grounds for disappointment or anger over what happened. Now, before I forget, though, I will say, bringing up Federalist 84 does, in a way, support the Federalist position in the later argument in this sense. Federalist 84, Alexander Hamilton deals with the argument that there is no Bill of Rights. And he makes a number of different arguments, some of which are in tension with each other, but I think they go together if you pay careful attention to how he qualifies what he says. I say they're in tension because in some parts of it he says, well, there already is a Bill of Rights. Then in other parts of it he says, we don't need a Bill of Rights. I think he harmonizes, though, by saying we don't need a Bill of Rights in the extent to which the Anti-Federalists are saying. There's already one in Article 1, Section 9, because there are certain prohibited powers to the federal government. Habeas corpus, bills of attainder, ex post facto laws are prohibited. Habeas corpus is protected. But they're calling for something more extensive, and Hamilton makes a number of arguments. One thing he does say in Federalist 84 that I think is wise, although it's sobering, he says, yeah, they're asking for a constitutional protection for freedom of the press, and Hamilton said, there is a definition for freedom of the press that does not give the utmost latitude for evasion. In other words, you're not going to be able to get a definition that will definitively tell you what the scope is. And everybody will agree, and this is even famously in all like Supreme Court justices do this all the time. You will have encountered it or you will encounter it. They'll say, such and such is a fundamental right, but it's not an absolute right. Right? So that's telling you that there's a lot of fancy footwork that has to be done to find out what violates it and what doesn't. I think Hamilton appears to be prescient in that sense because he might say, well, if anybody thought that First Amendment meant there no power over the press at all, that can't be the case. And even, as I said, I think the modern court would agree with that. But you're right. The Ninth Amendment was added. It refers to non-textual rights to kind of protect against this. This early controversy could be invoked to show like it's not really that effective because it's not clear what it means. But I do want to do justice to not the Anti-Federalists, but the Jeffersonian Republicans. They have a reason to be mad about this because leaving aside all the textual arguments and all the arguments drawing upon the legal resources, the history of the times is that could be fairly summed up like this. Constitution's proposed. Some of us complain that there's no protection for the freedom of the press. Some of you Federalists, including James Wilson, came forward and said, but not to worry, there's no power delegated over the press, right? And then we said, but we're still worried about it, and you guys said, okay, let's do a First Amendment, we added that. And then a few years later, they're coming back and saying, well, it turns out there is some power over the press by implication. And in general, it's hard to figure out who you would say was right about this, but that in general, that's the Jeffersonian Republican complaint about the whole Hamiltonian program, is that they feel that the Federalists may be engaged in what you might call bad faith constitutionalism, in arguing for kind of reassuring people that the scope of the powers is not all that great in order to get it ratified, and then once it's ratified, interpreting it according to a broader understanding of the powers than they were willing to admit beforehand. And that's a big problem if you believe in government by consent, right? If the Constitution was sold on the basis of what I called earlier false advertising, that would be a big problem. And I think Madison, thought that about some of Hamilton's program, and he probably thought that too about the Sedition Act. So it's not just a question of what's the correct reading, but the reading that we kind of agreed on when we were debating it. I mean, if you enter into a contract with somebody and after it's signed and in operation, they start bringing new interpretations in, you might feel not so good about that, especially if you said, don't we need to add a clause? And they're like, no, don't worry about that. Right? So anyway, yeah, Dr. Keys.
Thank you very much. That was a great talk. I wondered if you mentioned during your lecture that Blackstone, and when you spoke of Blackstone and the American Blackstones, right, that there are ways that the Americans liberalize the common law tradition. So I wondered if you could elaborate on that.
Sure. A couple of things. One is the one I already mentioned, and it's in the Sedition Act, but it's also in just the general movement in treating criminal libel like in affirming a truth defense for criminal libel. Let's put it that way, right? Because this sounds very important to us, and it is, because it's totally alien to our way of thinking that you could be held accountable for a libel that's true. I said something that's true about somebody, and that's still libelous, and I could be prosecuted. That seems strange. Before I come to answer your question, though, let me say something in defense of that, or at least to get us to think about it. So we are at, let us say, I can say this here, we're at one of the greatest universities in the country and the greatest Catholic university in the country. According to Catholic moral theology, detraction can be a sin. And detraction is saying something bad about somebody that hurts their reputation, even if it's true, if there's no good reason to do it, right? So you don't tell something about somebody just to gratify your malice, to see their reputation hurt, or just to gossip, right? So that's a sound principle of morality that I think was recognized by that generation that treated even a true libel as something that could be wrong, both because of what I said earlier about the danger to breach of the peace, because somebody who's humiliated in that way, you don't know how they're going to act, and we don't want to find out, right? But also just on the idea that it's wrong, to do that to somebody. And so you do find some of the American and English judges saying things that are very interesting to me, even in these cases where they'll say, this is worth thinking about. Even if the thing is true, if you're going to accuse somebody of something that wrong, especially if it's criminal, you got to leave that to the public authorities. You don't try to prosecute somebody in the press. We do it where they have a chance to respond, So they feel like there's something inequitable about that. In America, they end up adopting the standard that truth can be a defense, not that truth is an absolute defense, right? So, in other words, if you libeled somebody under the English standards, it doesn't matter if it's true in a criminal case. We're not going to listen to that. The question is, did you say it? Did you publish it? Does it threaten a breach of the peace? In the American context, a very important development here is People versus Crosswell, which is a New York case in which Alexander Hamilton was involved. Federalist editor was prosecuted for saying bad things about Thomas Jefferson when he was president. And Hamilton argued for, and the aforementioned Chancellor Kent agreed with, and the court couldn't really come to agreement on, but later it was written into New York state law that the standard is there can be a truth defense, and that's a liberalization. Now, it's a limited liberalization because, as I've tried to suggest, it's not an absolute defense. What they say and what they write into the law is truth told with good motives and for justifiable ends, right? So in other words, it's not simply malicious, it's not simply to trash somebody, but there was some reason to have to tell the community about this bad thing. And that, by the way, I'm glad you asked that, because that is where the law at the time of the founding does make some distinctions between public figures and private people. Not that you have a higher standard to prove actual malice for defamatory falsehoods about people, but there's a slightly different standard, they would say, in relation to this truth defense question. In other words, what they're getting at is the truth defense is more reasonably invoked if the bad thing you revealed about somebody is something about somebody who is a public official or standing for public office, because then it's not just gossip, it's a question of their character and you have reason to want to know it. So that's one of the liberalizations, I would say. Also, and it's a separate category, I guess. I've been treating it here, but seditious libel, right? It's not just true of criminal libel, but of seditious libel as well, that we don't want in a country like an aristocratic and monarchical country like Great Britain at the time, we don't want people publishing bad stuff about the government, even if it's true, right? In America, we're not going to do that anymore because people have a right to hear the bad things about the government that are true. That's helpful to our democratic discourse. Yeah. Or
So one question kind of related to that, I guess, would be the way that Times v. Sullivan sets the burden here, because it doesn't set the burden as an affirmative defense for someone getting sued. It sets the burden on the plaintiff, if my understanding is correct, to say that you have to say by clear and convincing evidence that this was actual malice. How much does that actually render a change instead of maybe, had it been the other way, more of an extension of truth as a defense if the defendant was able to say this wasn't with actual malice?
Okay. That's a very good question. Can I ask you a question?
Certainly.
What are you studying?
I'm actually a first-year law student.
Okay. I thought it's a lawyer's question. That is a subtlety. It's not one I've gotten much into, but it's very important. And it's another way in which our standards have drifted from the founding standards. You're right. How did you put it? It's an affirmative defense? Is that?
Correct.
In other words, the plaintiff has to show that the publisher published with actual malice. And we have moved, I think in general, in that direction. And that also is not entirely consistent with the way the founders thought about this. At the time, I think, the burden was more on the defendant in a libel case. And that also reflects this public culture, this moral culture that viewed detraction with moral suspicion, right? It would be more common at the time of the founding to say that if you publish something defamatory about somebody, and it's, and we're not sure whether it's false or true, that's going to be a question to be hashed out in the trial. It's more up to you to demonstrate the truth of it. And in fact, Brennan mentions that in the Sullivan opinion as one of the concerns, that according to the common law standards, once you sue somebody for libel, the burden of, it's obviously when you're suing somebody, you have a certain burden upon you. You have to prove the thing was published, right? But if it's published, and that's pretty clear from the facts, you can't really conceal a newspaper, right? And if any ordinary person looks at it and says, yeah, that's defamatory, for sure. I didn't get into this, but there are categories of like what's libelous per se, the kinds of things that are just defamatory to anybody, as opposed to things that are defamatory based upon complex circumstances. You get to that point, then the question is, well, was it true or not? Sometimes it's hard to tell, and according to the standards we're more comfortable with, the plaintiff's going to have to demonstrate that it's not true, whereas the founding attitude was more, the defendant might have to demonstrate that it was true, because after all, you're the one who took it upon yourself to put this stuff out there and stir up this hornet's nest around somebody's reputation. So that's another way in which we have liberalized beyond the founding, and another way in which there would be serious consequences to going all the way with the founders on everything relating to the First Amendment.
We have time for another question or two.
Thank you for the lecture. You mentioned towards the end that the culture at the time of the founding that was suspicious of defamation was likely not drawing from the standard Lockean tradition, because Locke doesn't talk about this. So I was wondering if you had done research into where that sentiment comes from a deeper tradition. I was wondering maybe, you mentioned Shakespeare talks about this, whether it's more of a classical tradition understanding defamation in this way.
Yeah. Well, I'm out to sea a little bit on that, but I'm happy to speculate based upon the few things I've seen. Also related to this is the question of obscenity and blasphemy. And the founders would have viewed those as abuses of the freedom of the press as well. And maybe not like on blasphemy, not necessarily for theological reasons, but in his comments on this, James Wilson says blasphemy is a kind of public nuisance, right? Making yourself obnoxious to the community. And I've read some cases where the judges are actually pretty careful on that, or the one I read, he says, blasphemy laws are not for use on serious theological discussion. And they're also not really for use on people who aren't Christians. So in other words, if some Jewish person says, I don't think Jesus is the Son of God, you're not going to throw a blasphemy charge at them. They're just affirming what they think. It's more for people who make scurrilous, abusive kinds of nasty remarks about somebody's religion in public, right? And in that same context, some judges have said this. This is pretty alien to our understanding too, but like one of them says, Christianity is part of the common law, right? Alexander Hamilton says somewhere, what is the common law but the law of nature applied to particular cases? But maybe not just any natural law, but the natural law is understood by Europeans who were deeply formed by Christianity, right? And I would suspect, by the way, I've never tracked this down, but in one of the concurring opinions, I think Justice White mentions an article that talks about the clerical origins of our defamation law. That'd be worth finding out about. But what I'm driving at is, these people were deeply formed by two things. Okay, I get to talk about Edmund Burke for a minute. What does he say? Burke says, the things that have made Europe are Christianity and the idea of the gentleman, right? So you think about those two things, they are both very protective of reputation, right? Jesus' ethics are boiled down to do unto others as you would have others do unto you, right? Do you want others digging up stuff about you that's true but defamatory and publishing it? You don't like that, then you shouldn't do it to other people, right? Similarly, the spirit of the gentleman, the spirit of aristocracy, is very protective of reputation. You're not going to trash somebody's reputation for no reason. So I think, that spirit has been lost to a considerable extent. Many people think that if they have something negative to say about you, they're totally morally innocent if it's true, without regard to whether it's really appropriate to put it out in public. So I suspect that's a big part of the influence. And I've noticed in some of the opinions written by judges, they say things that I think breathe that kind of ethics, like, you're going to publish something about somebody and then you're going to argue it's true. And they say things like, well, what if the thing you're publishing is something that has already been forgiven by the people in the family, right? Why are you publicizing this? Like this spirit that, everybody's got some bad things. We don't need to dredge them all up unless there's a real reason. So I think that's part of the reason that they find this morally questionable. It's actually a very beautiful passage. I like to think about it. Why are we dredging up things that may have been overlooked or forgiven by the people directly involved, right? Go ahead.
Thank you. Hi, thank you, Professor, for the lecture. Very interesting. I just want to ask about the last part. If you can, explain a little bit more about your thesis or your ideas about the right to reputation, and specifically, who do you think should do that balance? It should be in the courts, balance between freedom of speech and this sort of right to reputation. And how do you think this could be actually enforced? Actually, in thinking in a society in which press is highly disseminated, it's not like in the Sullivan times in which you have clearly press institutions. Now everything, like every cell phone, is like a social disseminator of ideas, right? So it seems like difficult to enforce. So I think it's interesting to know how do you think this could be done, knowing that there's obviously a problem in in leaving that part of the equation behind and only focusing in the unfettered debate of ideas or whatever.
Right.
So thank you.
Yeah, that's a very good question, or 3 questions. Yeah, I mean, I think rights are one way to talk about moral reality, as far as I'm concerned. And I'm happy that I live in a country that has affirmed the existence of natural rights, even though sometimes when I read certain people, some of whom are maybe famously associated with Notre Dame, think, well, there's philosophical questions you could raise about the idea of rights. Maybe it's not the only way, but it's a useful way, it's our way, to get at the idea that there is some moral reality that is obligatory apart from our own choice, right? And so I don't think it's plausible to just invent rights based upon subjective and idiosyncratic desires of human beings, but it does make sense to have rights that are based upon common and deeply felt desires of human beings. And if I'm correct that human beings are by nature sociable and maybe even political animals, as Aristotle says, then reputation is an important external good that everybody cares about as much as they care about their other property. So that would basically be my argument for why I think there's a right to reputation. And there's different ways to formulate that, but you know, the Bible doesn't talk about a right to property, but it says thou shalt not steal, right? And the Bible doesn't talk about a right to reputation, but it says you shall not bear false witness against your neighbor. So I think whether you're looking at it from kind of a natural law or natural rights standpoint, some kind of natural principle that says reputation is something worth protecting. I think given the materials that we have, my argument suggests that it would be more proper, given the underdetermination of the constitutional text and the history, to leave the specific protections more to legislation, and particularly at the level of the states. They will have to work out what are the proper protections for reputation. And I will say that I think it would be permissible under the First Amendment for a state to impose something like the actual malice doctrine, because they're not bound by anything in the Constitution to give exactly the same protection to everybody's reputation, although they may be bound morally to provide some protection. There's nothing clear that, in my mind, that would prohibit them from doing that, but that's different from doing what Brennan and the court did, which is saying this is the one-size-fits-all protection for the whole country. And then it would be a problem to apply these to particular cases, but perhaps no more problematic than to deal with any other matter of law that arises. I mean, you're going to have laws protecting various goods, reputation on the one hand, freedom of speech on the other hand. At some point, a jury will have to hash out who did wrong to whom in a given case. That seems like a very hard thing to figure out, but on the other hand, we have juries figuring out, you know, was this first degree or second degree assault, or was it manslaughter, or was it murder? These are all basically moral distinctions that we attempt to put into the law, and then we leave it to juries and judges helping them to figure out what is the best fit for this pattern of facts. So I think that's what you'd have to do.
Great, thanks very much, everyone, and please join me in thanking Professor Holloway.
Thank you.